So it looks like people joining is slowing down. So why don't we get started? I am super excited for this conversation. I read The Originalism Trap over the summer and knew immediately that this was a conversation that would be great for the CEBV community. So I'd really would love to welcome Madiba Dennie. Hopefully I said your name correctly. She's the author of The Originalism Trap, How Extremists Stole the Constitution and How We the People Can Take It Back. She's also the deputy director and senior contributor at the legal commentary website Balls and Strikes and was previously a counsel at the Brennan Center for Justice. Her legal and political commentary has been featured in The Atlantic, The Washington Post, and elsewhere. Um, She's taught at Western Washington University and New York University of Law, is a graduate of Columbia Law School and Princeton University. So thank you for joining us. I know it's later where you are, but we are so excited to welcome you to Arizona, Madiba. It's great to see you.
Thanks so much for having me. Excited to be here.
So I personally am very excited about this conversation as a secret lawyer because I don't actually practice. I just really found your book to be so clear, kind of funny sometimes, which I think we need in the legal profession. And I really appreciated in the preface of your book, you say that this book was an answer to the question of what was the point of my legal education anyway? And that really resonated with me. And this book is such a lovely answer to that question. So just to start out, would love to learn a little bit about more about you, your journey to the work you do, how you came to it, and what is the work that you do now?
Sure. Well, as you mentioned, I'm the deputy editor and senior contributor at Balls and Strikes. So with that and with the Originalism Trap, my work right now is really sort of taking in all of the legal nonsense that's happening and trying to make sense of it for both legal and non-legal audiences. I think that so often a lot of absolute terribleness is sort of gussied up in legalese. And so the people who are most affected by it even don't necessarily can have a full understanding of what's happening or why it matters to, or why it should matter to them. And so what I see my role as being as someone who, you know, is fluent in both legalese and normal human, is to try act as a translator and bridge that gap and try show people like, hey, like here's what's going on. Here's what this really means, like why it's important, why it's bad often.
Right.
And I'm glad you said that you thought the book was funny in points because that is also something I really enjoy doing in my writing. Not just because I enjoy getting my jokes off, but also as a political and like activist matter as well, because I think that a lot of their reasoning, that they being the Supreme Court and the conservative legal movement more broadly, a lot of the reasoning is so bad. And again, like it's gussied up. They seem fanciful. They have these like beautiful chambers and like these really expensive education, and so they make it seem like this is serious stuff, and you have to take me seriously. And so I think that there's value in laughing at these people. And I can take what they do seriously while not taking them seriously or the ways in which they do it. So I try to work a lot of that into my writing in yeah, just breaking down for the public in general, regardless of whether or not you have a legal background, what's going on in the world and why, we should be doing stuff differently than the way these jokers are doing it.
Yes, yes, absolutely. I really appreciate the translating from legalese into normal human English. I think that's such an important project to be doing. So yeah, to get started, I think, since 2022, more and more people are paying attention to the Supreme Court, especially, since they deconstructed and eliminated Roe v. Wade. Um, and a lot of the stuff that they've been doing is done under this banner of originalism. So to start off, can you just say what is originalism anyway? The term is out there in the world, but what is it and where did this term and this theory come from?
Yeah. So originalism is the idea that the meaning of the Constitution is fixed in time. Originalists would tell you that it's frozen at the moment of enactment, like when it was ratified. And however the public purportedly understood the document then is how we also have to understand it now. And somewhat surprisingly, given the historical valence, is this is actually a pretty modern idea. Uh, People have thought for a long time that history can or even should play a role in informing your legal interpretation, but only in around like the 80s did people really start going hard on the idea that this is actually the only legitimate way to establish what the Constitution means. So I think it was around the mid 80s when originalism sort of solidified, but where we really saw it beginning to develop and the sort of like early percolations, originalism, if you will, was sort of in the backlash to Brown v. Board, which I think is very telling about the legal theory, where one of the main arguments that the sort of reactionary right used after the Supreme Court said that segregated schools were unconstitutional was saying, hey, that's not what the founders meant. They didn't think when they wrote this document that it would prevent states from being able to have segregated schools. And so the Supreme Court doesn't actually have the authority to do this. So I feel like that's a very important starting point. It sort of shows you how originalism emerged as this tool to launder all the sort of like horrible gutter bigotry kind of stuff that we see folks want to find a way to say legitimately. And it gave them a way of sort of saying, it's not just me wanting this because I'm pro segregation or and I'm anti-abortion, but I'm actually being most faithful, more faithful than you, honestly, to the Constitution. This is like what the founders really wanted. And there are a few, well, there are several problems with this, but there are a few I want to highlight. uh,
Absolutely.
so one of the problems I want to highlight is they don't know what these people thought. The justices are not historians. Oftentimes, actual historians will even submit amicus briefs in some of these cases, trying to tell the court that they're going about this all wrong, or that like they were, looking at like a really narrow subset, like a really like yeah, really narrow window, and it's like, well, if you actually sort of like zoom out, that's not really what was going on at that time, or like you're missing this part. So to begin with, if we're saying like how they're actually applying this, like if they are sort of doing history, they're not really doing it right. But then sort of compounding that is, and I'm gonna quote here one of my favorite movies, Jurassic Park, when Jeff Goldblum's character is like, you were so preoccupied with whether or not you could, you never thought to think about like whether or not you should. And I think about that a lot, like with originalism. I think sometimes folks who similarly to me generally will like disagree with originalism, with its practice and its outcomes. They might still try to think about, oh well, you're doing it wrong, like focusing on the could part, like, oh well, if you looked at this historical anecdote instead, or if you consulted this archive, then you would see that you were doing it wrong. And so I hear and sort of like encouraging people to take a step back and think about, is this even something we should be doing? Because I would say no, that we should not be making our constitutional interpretation touchstone like a single point in time. I would say we should be looking at principles instead, and that there is a structural failure involved in making all of our interpretation necessarily linked to the time of the founding, because at the founding, much of the country was much worse off. And again, I'm like, the people who promote originalism know this. That's the reason why they like it. Because it, provides this way of entrenching the political and the power dynamics of that era, so it gives like more power to like your like wealthy white male minorities, while dramatically disempowering every other type of minority, whether you're a person of color or a woman, or you have like a different like sexual or gender identity, like all sorts of stuff. Like your rights are on the chopping block. And I think that's a way in which originalism is sort of inherently dangerous, because it means that if you ever had to fight for your rights, you or people like you at any point in time, there's like a burden, there's an obstacle already put in your place. There's like a presumption of some sort of invalidity of your rights. Whereas everything that they claim they can find a source for way back when, 250 odd years ago or so, that's fine. But if you had to fight, as much of America did, then your rights are called into question. And so I think that it's just a morally bankrupt method of constitutional interpretation, on top of being, very intellectually weak as well.
Yeah, I think the talking about originalism and like the cherry picking of history just really struck me. And I think Justice Jackson in like I think a footnote or something mentioned this of like even if you were looking at the historical record, they never look at any to the extent there's a historical record written by Black folks or women or Indigenous folks, that historical record is never referred to as who the people are who understand the Constitution or had thoughts about
Right.
the Constitution.
Yeah, it's a very limited subset. Like even if we allow that they are thinking about the public, like say like broader than just like literally the individual men who like signed the papers, even if we're looking like beyond that, where how are they getting that information from, say like newspapers written at the time, or like some dictionaries, that contemporaneous dictionaries? Are they looking at like slave diaries? Probably not. Are they looking at like indigenous peoples like storytelling? Probably not. So there's a lot that gets left out, again, sort of making this very tiny idea of who gets to count as the public, who gets to count as the people, and like a real part of the political project, that leaves out a lot of folks. So I really understand the appeal, and do think there's like some utility in folks saying, you're saying that there's this history, but like whose history? Like what about the rest of us? I think it is, good to point out folks that are being left out, but I also think that we need to be really, we need to make sure we don't get too short-sighted and get caught up in just the idea of proving them wrong on the history, as opposed to thinking about like what are our actual goals? Like what are we trying to accomplish here other than just proving them wrong on the history?
Absolutely. And to that point, one of the things that you spend some time on and point out is um, part of the history that they ignore, but is also related to the principles, are the 13th, 14th, and 15th Amendments, which really radically reshaped how the Constitution maybe could be interpreted.
Yeah.
Um, and you talk a lot in your book about how these Reconstruction amendments really could be a source of expanding justice and access to justice. Could you talk a little bit about why you think these amendments are so important in our understanding of the Constitution?
Definitely. So the 13th, 14th, and 15th Amendments are those amendments that were added to the Constitution in the wake of the Civil War. And so they, constitutionalized the formal abolition of slavery, with the exception of as punishment for a crime. It recognized and like guaranteed equal protection under law. It recognize that people have a right to due process of law. Again, all people. It doesn't say just citizens or some subset of the population. It says people. The 15th Amendment, it guarantee that people have this time it does say citizens, but 14th Amendment, that's it says people. So also I'm like, they know how to say people and versus citizens where they want to. So so there's no reason to read in citizens to the 14th Amendment. um but the 15th Amendment guaranteed that citizens' right to vote will not be, like diluted by like racial discrimination. Like it wouldn't be infringed or violated on that basis. And also importantly, all of these amendments included a clause that gives Congress the power to enact legislation to enforce these guarantees. So this does a sweeping overhaul of the way the Constitution worked up until that point. Like previously, it was just very much, slaveholders' document, working to protect like people and like this the rights of states, much more so than the rights of people. And the Reconstruction Amendments really upended that and also recognized that the federal government has a responsibility to all of the people in the country of ensuring that there is this baseline level of egalitarianism, to expanding the political project, including these people who had been forcibly excluded. So it's just a very dramatically different document. And I think that that is really tragically ignored often. The like Reconstruction Amendments they're treated as if it's just kind of like an afterthought or like not a real part of the Constitution, or even if folks like are recognizing them and giving them some teeth, it's still sort of constrained, like just to like the narrow text of those amendments. Whereas I would say that they should recontextualize everything else that came before it. So that's a big part of the argument I make in the book, where I advocate for a new model of constitutional interpretation, one that I call inclusive constitutionalism, because I think that the whole point of the Constitution, as amended by the Reconstruction Amendments, is to build an inclusive, egalitarian, multiracial democracy. So whenever we're interpreting any part of the Constitution, we should be doing so with that in mind. Like we should be looking through the lens of the Reconstruction Amendments and thinking, if I was taking these provisions seriously, what would this actually mean? Or like what would interpretation here look like? Like how would the political and legal system have to change if we were serious about the Reconstruction Amendments? And so they think there's so much untapped potential there, deliberately so, because the Supreme Court and like other political actors have often stepped in to try stamp out that power, because it it can do so much, it is capable of so much, and so they try to weaken it. And so I very much believe that we should go harder, basically. I think that sometimes there's this inclination of, well, I guess we can't use that now. And I'm like, don't give it up. If anything, we should be fighting for it even more. We should be like pushing those boundaries further. Like that's really sort of like what the Reconstruction Amendments are all about. Like I think that there is a just undefeatable, like inescapable conflict between the originalist idea of, everything has to be fixed in time, like things can't change, we have to preserve this, when the Reconstruction Amendments literally are imparting to us this liberatory agenda, telling us go out and change things, go out and make things better. Like we are now, recognizing like people's right to equal protection under law and saying that the government has the power to do something about it. And so I think that's just doesn't even I think it's impossible to reconcile that with the originalist idea of keep everything in place, because the Reconstruction Amendments make the Constitution, more so than they were before, like an aspirational document. And so how can originalists tell us to stop striving? It doesn't make sense.
Yes, I love that reframing of how do we look at the Constitution because I think it which we're gonna talk about later, but it gives a role to non-lawyers to be a part of constitutional interpretation, which I think as a group of activists here, I think is super important. But before we get there, one or two areas that I think are really influenced by how the court does or does not incorporate the Reconstruction Amendments when they're interpreting the Constitution are voting rights and the census, which is also both issues that are at like the heart of a lot of the work CEBV does, right? Is
Mhm.
since civic engagement is our focus. So just starting with voting rights, because there's a case in front of the court right now, and I think it's really on top of mind for a lot of folks. Can you talk a bit about how the theory of originalism has been used to define the right to vote and who gets access to the ballot?
Yeah, yeah. So originalist ideas, or this overemphasis on the past and purported original understanding, have repeatedly creeped in to the court's decision making, in often in, I would say, somewhat strange ways. So if you look at Shelby County versus Holder, for example, that was the case about a decade ago that was the first really big gutting of the Voting Rights Act, where they said that they had this part of the Voting Rights Act, Section 5, which was the pre-clearance provision, looked at states and local governments that had like a history of discrimination and said that, okay, like you have a bad track record, so before you go making any changes, run it by us first, us being the Department of Justice, or sometimes a three-judge court in DC, and we'll tell you whether or not you can move forward with that change. And the court didn't strike that part down, but what they did was they struck down the formula used to identify what states are covered. It's like a classic cheeky John Roberts maneuver, because he gets to say that he didn't actually strike it down, but he made it entirely unworkable. I think of it like boosting the wheels off a car, or like taking the engine out. Like it can't do anything if it doesn't have the formula. And the way that he tried to justify this, to say that this was unconstitutional, basically saying that it aged out of constitutionality, saying that it didn't make sense that these states were still being covered by this out-of-date formula because, you know, we're like this post-racial nation. We have like a black president now, and and states are unfairly being treated differently despite this like historic principle about equal sovereignty. And I'm like, what is this historic principle that he's talking about? And so I go looking. First of all, he got the name wrong. It's not even called equal sovereignty. It's called like the equal footing doctrine. And second of all, it's about something completely unrelated. It was about the conditions under which some states are and were being admitted to the union. Again, like 250 odd years ago, saying that you can't put like different conditions on one state than another when they are becoming part of the United States. And third of all, it wasn't even consistent in practice back then, because like people because the government did put different conditions on states, most notably in the wake of the Civil War, when states were being told, oh, if you want to be part of this union again, you're going to have to ratify these amendments. So it was just complete nonsense, but in this sort of like I like to call this sort of like original-ish, instead of necessarily like originalist, because it just, this originalism hued, like flavored, originalism infused opinion, where he's just sort of pulling in these ideas of, oh, well, the founders this and the founders that, and like you have to go based off this historic understanding. And when you look just a little bit closer, the historic understanding is like literally just John Roberts making stuff up. Um, and like there's this one like really egregious part where he like claims that there's has to be like a geographical like closeness, that there's like a relationship between whether or not the law is constitutional and like how it is relevant to like a specific like racist ill in a given place. And if you look at like what he is citing to support that proposition, it says the exact opposite. Like he just put some strategic ellipses, like dot dot dot, like in the middle of the sentence. So just completely intellectually dishonest and deeply frustrating. So that's like one sort of nods towards originalism. Like look at the history and things are different now. Um, but another very strange one was I want to say this was DNC versus Brenovich, which I think is that like that's y'all, right? Arizona,
Yes,
like Brenovich.
that was
Yeah, okay.
us.
That was I'm like that was you guys. Yeah. Where the DNC had challenged various, you know, like voter suppression laws in Arizona, and Justice Alito sort of like breaks out this new original-ish type standard where he comes up with all sorts of guideposts for assessing whether or not like a various like voting provision in a state like is like violates the Voting Rights Act, and they all seem just pulled out of thin air. But what was one of the really absurd parts was that he was like, well, the Voting Rights Act was amended in 1982. So if we're assessing the like legality of some of these provisions, we should say that like anything that was common in 1982 is presumptively legal. And it's like, what? That makes no sense. It's just again this sort of like vaguely originalist idea of you know like interpretation based off of like what was happening at the time it was written, but it was really just like Sam Alito doing his own thing, like rewriting the statute to work the way he wishes it were written instead. And the way in which he wishes is to like dilute the Voting Rights Act and the Reconstruction Amendments of their power. And again, thinking about these really selective uses of history, at no point in this are they looking at all of the evidence about the Reconstruction Amendments being promulgated and the Voting Rights Act as well being written and then amended later to stamp out like racial discrimination in voting, to like actually allow people of color an equal chance to participate in the political process. They just ignore all of that history because it's inconvenient, and instead they you know slice and dice or invent like to fill in those gaps. So there's really preposterous stuff that I think underscores the illegitimacy of originalist decision making and also the illegitimacy of the Supreme Court more broadly. I think that, you know, looking at some of these decisions, folks should really understand again, like that why I was making fun of them sometimes. I'm like, because you should not be taking these people seriously. Like, this is not smart. They are not smarter than you. They do not just like know something you don't. Like, they are just making stuff up in order to accomplish the things they want to do. So like you don't need to give them any sort of undue respect when this is just nonsense.
One question from the chat that I think is related to this issue of voting is because people complain about it, rightly so, in politics, is um, talking about corporations as people with it
Mhm.
and being able to operate as a person within politics. And just curious of like, how does originalism reconcile this? And is there an originalist argument for corporations being people and being able to operate as people within politics?
Right, right. I think the within politics is an important qualifier because I think there is some long-standing idea of corporate personhood in terms of making it possible to sue corporations, like you like someone might sue another person. I think that's like a very like an old-timey like historic principle. But treating a corporation like a person in terms of having political rights, that that seems that's pretty new. This was a pretty dramatic change to the way like the constitutional interpretation worked, and you know, and our political process is suffering as a result because it like allows the like ultra wealthy to uh really exert all this extra influence, extra dominance in our political discourse. So yeah, it doesn't really make much sense. I would have to give a closer read. I would have to sit down and read Citizens United a bit more closely to see like if I can identify a specific originalist language in there. I can't tell you I know right off the top of my head. But yeah, I think that it may be I would be unsurprised to see some of what I've described before about this like loose historical references, because I'm like, I'm just thinking about how corporate personhood was a thing in the like lawsuit jurisdiction contest, so I can very easily see them being like, yeah, corporate personhood, we that's been a thing, that's fine, and just sort of like acting like it applied somewhere else. It's like similarly to the way John Roberts did with like equal footing doctrine suddenly becoming equal sovereignty, and being able to take down the Voting Rights Act. So yeah, that's what I would suspect, but I can't say I've recently done a close read of Citizens United, so I wouldn't want to make any assurances.
Absolutely. I think we're touching on something. So in one of our other trainings that we host, we have a media literacy training that talks about objectivity and whether objectivity is even possible in journalism and what does that look like. And I think similarly, many of us have been taught or sort of assume that judges are supposed to be these neutral or objective arbiters of justice when they're making decisions. And I will say in law school, I found one of the most frustrating things,
Yeah.
concepts that people talked about. And in your book, you talk a lot about originalism is neither neutral nor objective. So can you talk a little bit more about what are your thoughts about objectivity in the law? And is that the standard we should be striving for, or is it even possible? Like
Mm.
what does it mean to have objectivity or not, as our standard for the law?
Right. Yeah, I do think in some ways that objectivity, well, let me think. Like, are we equating objectivity with the idea of neutrality and of like not taking a side? Because ultimately, we do have to take a side. You're going to issue a ruling one way or the other. And also, like, there's a difference between, you know, trying to be even-handed, like treating things are like as they're just like as if they are the same, like sort of like both sidesism, versus being even-handed or being fair as in like being honest and accurate. I think that there's sometimes people will say they're being objective or neutral, by ignoring all relevant context, and I think that does not read as neutrality to me. That's just a different kind of bias, and I would say a worse bias because it is deliberately ignorant. It's missing a lot. I don't think there's anything uh neutral about sort of like pretending that like these sort of like discriminatory conditions like don't exist. uh like I'm thinking perhaps as an example, of thinking about like objectivity and neutrality. I'm thinking about Justice Alito insisting, and I think it was Brnovich, that you should sort of assume that state lawmakers are passing constitutional laws and that they wouldn't discriminate based on race. And I'm like, why would I assume that? As like on what, like based off what, like on what reason would I assume that? And I'm like, I don't think that's subjective or like neutral. I think it's just foolish. Like it's just like untethered from reality. So I think there's a big difference between the two things. So I think they get conflated a lot. That people say they're being objective or they're being neutral when what they're like actually doing is just shielding themselves from reality, and that is not okay in either our journalism or our jurisprudence, I believe. I think that it is reasonable and good, to take into account like what's actually happening in the world. um like obviously, sure, there are limitations, like you don't want a judge doing some like completely random research or something. Like you don't want a judge doing like the equivalent of like WebMDing, like when you where you're like, well, like I was on Reddit today and I saw this, so like you don't want any of that, obviously. So like not saying that there aren't like limits, but you should be able to use your brain, and be able to like use your senses, your eyes or ears or what have you. Like I'm thinking here about uh, Justice Kavanaugh's opinion in the racial profiling case, and how he just ignored entirely the like all the actual findings of the lower courts, saying, like what discrimination looks like how these ICE raids are actually happening in practice, like how people are just being snatched off the street willy-nilly because they're Latino or because they spoke English with an accent. And instead of grappling with any of that, he had Kavanaugh like, oh, I don't think that happens. I think that, if you're a citizen, all you have to do is like show that you're a citizen and then ICE lets you go. And that is, like there's nothing, that's not objectivity, that's not neutrality. That's literally he just made stuff up. And even if he didn't have the lower court's record, which he did and should have used, but even if he didn't, like, does he not have a TV subscription? Like, has he not seen any of the viral videos of these like horrible kidnappings? So I feel like that's something where it should be like, open your eyes, man. Like, look around you. Like, you should know what this looks like instead of just inventing this alternative fantasy land that is just completely unrelated, like not grounded in reality at all. So I think that that's a real failure of not engaging with the world around you, and not looking at things, honestly. And that includes, taking the accounts of people of color and, of women, of queer people, like taking those accounts seriously, weighing them equally. Like perhaps, if you want to talk about like neutrality or objectivity, saying like, are you crediting the like inputs and like the thoughts and of like marginalized groups the same as you are others? I think not. And I think that sort of real objectivity comes in again. I think I saw a question about the shadow docket. um on the shadow docket, often you're supposed to be making assessments about like a balance of harms. You're supposed to do like a weighing. And you're supposed to say, okay, like what is the public interest here? Like what's the burden on the government? Like what's the burden on this affected person? Like are they going to be experiencing some kind of harm that is like serious and can't be undone? And the Supreme Court's like, like the six justice majority frequently, like time and time and again this term, has been saying, yeah, the administration meets that hurdle, like these people do not. And if you are actually being objective, you would say that that doesn't make any sense. I would say, like, in what universe does the inability to start discriminating count as irreparable harm? Like, like an example that comes to mind is the like order like forcing trans people out of the military. And I'm like, okay, so on one hand, you have people losing their jobs and being, like discriminated against because of who they are. And also like uprooting the way that the military is working, just like all sorts of problems. And on the other hand, you have Trump wants to discriminate against trans people right now. He doesn't want to wait to even figure out if this is legal because it was just like an interim order. It's like he doesn't want to wait. He wants to discriminate right now. And the court's like, yeah, that sounds worse to me. He should be able to start discriminating right now. I'm like, nothing about that is objective. Nothing about that is neutral. This is just, like rank, like gross ideological decision making. And again, I'm like, not even a good ideology.
Yeah, it's like, but if I don't get to be racist right now, I'm going to be really sad, and that's a problem.
Yeah. You can't expect me to go another day without being racist.
So you've already provided some examples and a little bit about your proposal for inclusive constitutionalism and another way of thinking about how can we read our Constitution and use it to expand access to justice. Can you just kind of give a bit more like summary or overview of what do you mean when you talk about inclusive constitutionalism?
Yeah. So I think about the sort of goals behind the Reconstruction Amendments. So again, I'm like expanding the political process, creating this uh, like multiracial democratic society in which everyone can participate. So like establishing the sort of like baseline level of, like political, social, and economic needs are met, and people can, like engage in society in that way, and can exercise, like a real political voice and be able to, participate in self-governance. I think that is something that is really being lost a lot today, like like including but extending beyond the attacks on the vote. Like I think of Trump's military takeovers of cities as really depriving places of their self-governance. Like, he's like displacing their like elected local leaders, and sending the troops in. And I feel like there's a problem with that, like it like that conflicts with the sort of like, idea that, the Reconstruction Amendments were letting all of us, even if we, depend, even, regardless of what our skin color is, or regardless of like what state we live in, like whether or not that state has a governor that made Trump mad, that we have, the right to equal protection under law, and, to self-governance, to like have a democratic society. So I think we're seeing all these things that conflict with that whole sort of like guiding principle, like with that ethos. And so when I say, inclusive constitutionalism, I'm trying to think really comprehensively, like across like lots of different, issue areas, like not just the vote, or like not just abortion, but like broadly, what would liberation require, and like how would, like how do we sort of constitutionalize our progressive goals?
Yeah, I think I mean I just cannot say how lovely I think the theory is and just how um like being able to look at the law and say we can put our ideals and our values into this as opposed to remove them. Because I feel like one of the things originalism does is it like every
Pretends
time
to
I
be
read a
removing.
decision, it like requires me to remove my values in order to agree with the outcome,
Right.
which seems wrong, right?
Yeah.
Like it just seems wrong that we can't
And
have
I
values when
and
we
I think
interpret our
that
constitution.
Yeah, and I think some of the justices, maybe not all of them, but I think that some of the justices know that's wrong as well. I think we saw that in Rahimi, the gun rights case, involving a person who had like a domestic violence restraining order against them, because when confronted with the natural conclusion of their originalist reasoning, which a lower court found that, there weren't domestic violence laws in, the early days of the United States. There was no like deeply rooted historical tradition of disarming domestic violence offenders because they were okay with domestic violence. So we couldn't disarm this domestic violence offender. It said that the law taking guns away from someone who was like, I mean, I'm not. I shouldn't say it's funny, but it was like if you look at the fact pattern of Zaki Rahimi's case, he was just like very clearly the least responsible gun owner of all time. It was like the worst possible poster boy for their lawsuit because this man like never had a problem that he thought he couldn't solve with a gun. Like it was outrageous. He like pulled out a gun when his like friend's card got declined at a Whataburger. It's like, sir, please be serious. And so when the Supreme Court uh when that appeal came up to the Supreme Court and they saw, how applying their decision, what it actually looked like, most of the court was like, oh no, oh, we can't have that. And they're like, oh, we didn't mean that. The lower court, they didn't understand Bruin. They didn't apply Bruin correctly. Bruin being the case where they laid out their original standard. And they're like, oh yeah, for these random reasons, they're again doing this sort of historical grab bag thing, trying to find random stuff to justify their decision. They're like, oh yeah, the that law is actually still okay because of these random, not really applicable historical analogs. Because yeah, they did not like the consequences of their actions. Now, hilariously, there was one dissent in the Rahimi opinion, and it was Justice Clarence Thomas who wrote the majority opinion in Bruin. And so when you had almost all of the court, and Rahimi saying, "Oh, that's not what Bruin meant." You had Thomas in dissent, like, "The hell it wasn't. That was exactly what I meant." uh, but the rest of the court was not trying to go along with that. Um, so yeah, we know, and they know that removing your values from the equation can take you to some pretty dark places pretty quickly, especially if you are trying to base your constitutional interpretation on, like old-timey standards where things were worse for most people.
Right.
So like, yeah, I'm like, that's gonna get real dark real fast. And they know that. And so I think in a way, they're all sort of pretending about like removing values from the equation anyway. So we should just talk about like which values should be included. And I would say that we know which ones should be included. The Constitution tells us which ones. Values of like equality, egalitarianism, multiracial democracy. Like these are things that are included in the text of the Constitution. So it's not even just me, having like my little leftist dreams. I'm like, this is right there, like in the document. Like we have the tools we need.
Yeah, I so appreciate that. And I will say one of my favorite chapters, because I am at my heart an organizer and activist, was the final chapter. And I really appreciated that you spent time really taking seriously what is the role of non-lawyers in this project, right? Like this isn't just about, you're part of the handful of elite lawyers who get to argue in front of the Supreme Court, but like the rest of us on this Zoom also have a role in how do we define the Constitution and how do we talk about it? So can you share a little bit more about like what's the role of non-lawyers? What should we be doing if we are hearing you and saying, yes, my values should be reflected in the Constitution and are,
Yeah.
what is our role as an activist in helping make that real?
I am so glad that you like that chapter a lot. Because I was, really thinking hard about like how to make this real and think about, like I want inclusive constitutionalism to be useful for people. So I'm very happy to hear that that resonated. So yeah, I talk a lot in that chapter about, trying to basically like think about like how the Constitution could apply to your life or like what issues you're working on, and like invoking it, like claiming it, like making your constitutional claim, where like if there's a provision you think is relevant and like could and should apply. And one of the examples I give, I'm like we talked about the 13th Amendment a bit earlier, and how it like constitutionalized the prohibition on slavery. And so, one of my arguments is like if we recognize that, people have a right to not be like coerced into like giving their labor, should we not assume that they have a right to stop working and negotiate the conditions of their labor? So like that would be a way of like including the Constitution like in your like unionizing and like striking efforts, and trying to like overcome some of the like legal obstacles that are put in the way of unions and striking by saying actually we have a higher law, the Constitution is on our side, so like tough luck, and like reframing that conversation, like changing that narrative, because honestly like a lot of constitutional interpretation like really is just about like narratives. It really is about like conversations and what you get enough people to agree to over time. So I think like we should ask ourselves like what do we want people to agree to, like what do we think, like what do we think is the right way to understand this, like how is the Constitution potentially like relevant to our lives. And there are some like historic examples of this that I speak about in the book, like one of my favorites being like the Montgomery bus boycott, because I think that we can't understand the Supreme Court saying that like segregated buses were unconstitutional without thinking about all the people in Montgomery who had already been saying segregated buses are unconstitutional and refusing to ride the bus, thereby like putting their constitutional vision into practice. So I just think we should like identify and seize like any such opportunity to basically implement our constitutional vision already. Just like go ahead and do it. Like fake it till you make it. Like we can make our idea of what the Constitution should be happen by just going ahead and doing it. Like I think that that's this really like underappreciated value to doing so. And some ways it can be like bolder, like strikes or boycotts, and sometimes there are even like ways to do this that are more perhaps more comfortable. I'm thinking about like a lot of the like state campaigns before the Supreme Court held that same-sex couples have like a constitutional right to marry, that there was like a really diligent like state by state campaign like changing the laws in the books in lots of states, and I think in doing so sort of like changing the conversation about like what the law means and like if this is constitutional or not, just sort of like shifting it along and like making it harder for the Supreme Court to say no, it's not constitutional. So yeah, I think that there are like a bunch of possible ways that you can, yeah, basically like start making your idea like what's legitimate, and like delegitimizing these terrible originalist ideas or like whatever these reactionaries throw at us, and putting forth our own different concept of what the law can and should mean.
Yeah, I think that's, a tool that I don't see being used much. I think in activism we talk a lot about our values, but we don't necessarily draw on like the founding documents of this country. We've sort of ceded that ground and said, oh, well, we don't get to claim that. And I really love this
Yeah,
idea of saying, actually, if we're fighting for progressive values and fighting for liberation, let's use all the tools in our toolbox. And one of those tools is, in fact, the Constitution and the Reconstruction Amendments. And we have just as much right to that as conservative legal theorists who have built up their
right.
originalist arguments.
Yeah. I think I understand why folks might be reluctant to like invoke the Constitution, because like we were deliberately left out, or like these laws like have been used against us often. But they also very much don't have to be. Like people can and have changed what these laws mean. And like if we know that like the law means what enough people want it to mean, then what do we want it to mean? And like what can the law like do for us instead of just to us? So I think that there's like an opportunity here in terms of like like in terms of like political power and what the Constitution is capable of, because it has been capable of things that have helped us. And also I think another missed opportunity is, even though I think sometimes that folks like left-leaning activists can again, be just like so done with the idea of like the Constitution or law and like sort of like institutions, because like we know how much institutions have failed us. But I'm like, okay, but like think about the normies. Think about think about the people who may not be where you are yet. And the idea of these institutions and of the constitutions like often is something that really resonates with them. And so it's a way that what you're fighting for can resonate with them too. Like even if they might not recognize like what you're fighting for in the abstract, if you then get them to believe that the Constitution protects that, then you might get them to come around on it. And so I think that there's like a strategic value as well in thinking about how we can work with the Constitution.
Absolutely. I think there's like 15 more questions, and we have 2 minutes, so we're not going to get to them all. But this has been such a lovely conversation. I do want to tell everyone, go to your library, read the book, go buy the book. If your library doesn't have it, ask your library to buy the book.
Yeah,
Um,
libraries do that, I've learned. It's awesome. If it doesn't have it, you can just ask them.
I just I did that. I submitted a request a few months ago for not your book, they already had it. But for another one, and I just got a notice that our local library bought the book that I suggested. So
Love that.
if your library doesn't have the originalism trap, go tell them to buy it. But as a final question, um, you spend all your time reading legal decisions, most of which these days are pretty terrible. So how do
Yep, yep, that's
you
true.
so how do you stay hopeful and keep a hold of your vision for justice in the face of just constantly having to read about all the harm that courts are doing right now?
Yeah. Yeah. No, it is a real it is a real challenge. Sometimes there are some days it's harder than others. But there are a few things that I think help. One is like doing the work. I think that I basically always feel better when I like do something like this, like talking with people about the law and how things work, or like going to a protest or something, or like being in community with like-minded people, remembering that like I'm not actually like alone in this. I think that that's one thing that helps. Another thing that helps is, like knowing when you just got to take care of yourself in whatever way that could look like, whether it's sometimes honestly just like lying down, like you physically need to rest, unless or else like you won't be able to continue doing some work, or like checking out for a bit, like reading something, watching TV, what have you, just like doing something that like gives you some comfort and joy, like reminding you like there are good things out there, like hanging out with good people in your life. I spend too much time making desserts. I'm like, I need to find a coping strategy that's
Is
less
there,
bad for my blood
I
sugar.
don't know if there's
But
such thing as too much dessert.
but I think probably the most important thing that gives me hope is just remembering the successes of other activists, that like people who worked in darker even times than these and like still had the audacity to dream and fight for better, and often to see those dreams become reality. And so I think, all right, if they did it, I can do it. Like if they fought, I can fight. I still think this is possible. um I I sometimes there's a movie I watched like once. It's like a completely random movie. Like doesn't matter. Point is, there's a line in the movie that says something to the effect of like, what one man can do, another can do. And I feel like I just like clung to that line, and I was just like, yeah, like what one man can do, another can do. Like if they had that fight, I can have that fight. Like they overcame this, I can overcome that. And yeah, so I feel like it gives me a lot of hope and energy uh thinking about really cool work that people have done in the past. Like if you ever need to get hyped, just like read over some historic wins, and you'll be like, yeah, like that's pretty dope. We're in this.
Thank you so much, Madiba. This has been just such a lovely conversation. I so appreciate you making time in your evening for us. And please, everyone, go out and read the book. It will make you feel better, which is not something I usually say about reading about the Supreme Court, but I will say it about this book. It will make you feel better.
Thank you so much.
All right. Thank you. Have a lovely night, everyone.